morning. I'm Jack O'Donnell, the managing partner of O'Donnell and Associates, a state and federal government affairs firm. We provide advice and counsel to clients in fintech, AI, e-commerce, digital assets, and other parts of the financial sector. In all my time in the public and private sector, few issues come to mind that are more complex than data privacy. Data has taken an increasingly prominent role in the lives of consumers and in the operations of businesses. The risks continue to expand while regulations become increasingly complex and hard for small businesses to follow or even understand. My role and the role of the Data Privacy Alliance is to use knowledge and information to collaborate with government officials in order to find the right approach to regulation and find an approach that protects consumers while allowing good actors to thrive and continue to grow their business. Today, we have a great panel and we're really looking forward to a good discussion of these issues. I especially want to recognize Senator Thomas, who's been a leader on these privacy issues as well as on other consumer issues. I'd like to recognize my friend and perhaps the hardest working and certainly most productive member of the New York State Assembly, Linda Rosenthal, and another great friend, Senator Diane Savino, who's the chair of the Internet and Technology Committee, and, may I add, a nationally recognized leader on elevator safety. Anyway, thank you for joining us for what I hope will be a great discussion of how we create a regulatory framework that encourages innovation while protecting public safety and protecting the privacy of New Yorkers. With that, I'd like to recognize my colleague, Jim Moore, who's the Executive Director of the Data Privacy Alliance.
Thanks for the introduction, Jack, and thanks to City and State for hosting this event and for our fellow panelists. So my name is Jim Moore, and I come to this space as a policy professional who works with various stakeholders in industry who touch data. The Data Privacy Alliance is a group of for-profit and non-for-profit stakeholders who have the benefit of resources like Beckage law firm, who's a leading national law firm on data privacy, and O'Donnell Associates on legislative advocacy. We work with members from fintech, artificial intelligence, healthcare, and a number of other areas of industry that are concerned with data privacy, data security, and really mitigating risk. And our mission is simple, and our goal, it's to contribute to public discourse on the appropriate policies, that mitigate risks while, encouraging innovation throughout industry. And before I get into the specifics of the New York Privacy Act, taking a look at the environment around data privacy policy, the regulatory frameworks around the data economy that underpins the apps that we use on a daily basis is rapidly changing. Perhaps most significantly, the Schrems 2 case, which was decided in the thick of COVID last July, invalidated the EU-US data privacy shield, which came from the world's first comprehensive data privacy regulation, the GDPR. And without delving into the specifics of that, that's important because it really kickstarted the conversation across the US, both in Congress and in state legislatures. In DC, the issue's been intensely deliberated on. You've probably seen press releases, discussion drafts, so on and so forth, but it has yet to be really acted on. There are, upwards of 30 bills in Congress, last Congress in the 116th and in the current Congress. But really where Congress is torn is between two approaches. You have Senator Roger Wicker and the Republicans who really are taking the approach of, a federal framework that would preempt state policies like the New York Privacy Act. On the flip side, you have Senator Myriah and the Democrats who, really are pushing more of a guidepost or, a baseline for states to then build off. That's important because as you've probably seen in every policy area, until the Senate Committee of Jurisdiction can reach, a compromise approach, nothing's going to happen. So all of these hearings, press releases, Senator Roger Wicker calling on the White House to drive policy, until they can reach that compromise approach, nothing's going to happen. So we're left with kind of a complicated mishmash of, sectorally focused laws, HIPAA, FTC, Gramm-Leach-Bliley, that really focus on healthcare or, the financial data. But there's no overarching, comprehensive data privacy framework. So in the absence of that, and in the interim, states are taking the lead. And it's still early to see how that's going, right? You've basically 3 state laws that have been enacted: Colorado, California, and Virginia. And what we're watching is to see how those states balance, the protection of consumers and, avoid pitfalls like you've seen in Illinois with, cascading litigation and gridlock around BIPA, which was passed around 2008. So in the first year of data privacy enforcement in California, the Attorney General's office announced this July that they've basically resolved or adjudicated 75% of violations within the 30-day notice to cure period. While it's impressive, that's still a quarter of the cases in California that have been left unresolved, perhaps underscoring larger issues. And in California, I'd also note, we're going to see an amended framework from the CPRA, which passed through ballot initiative last fall. That goes into effect January 1, 2023. That's the same idea in Virginia. It's early to see how these frameworks work operationally. And that brings me to the big question for today. What would and should this look like in New York State? And really that conversation starts in 2019. On the heels of the SHIELD Act, which was a bill that dealt with data breaches and data security, Senator Kevin Thomas and Assemblymember Linda Rosenthal, who are joining us in a little bit on the panel, introduced what was one of the first data privacy policies proposed in the country in the state legislature, the New York Privacy Act. Put simply, to take a 20-page bill and boil it down to a quick paragraph, the New York Privacy Act obligates certain companies to disclose their methods of de-identifying personal data, to install safeguards for personal data sharing. And one of the big pieces is it creates a consumer bill of rights that is a consumer's right to notice, access, and deletion of data. One of the biggest thing the bill does is creates an opt-in framework. So for data sharing, data privacy policy right now, by default, we operate under an opt-out framework. So not to delve into too much of the technical side of that, but what an opt-in framework looks like is if you ever go to a European newspaper's website, you'll see, a very clear notice on the use of third-party cookies, and you actually have to click accept to that. And that's on the consumer side, that's 2 clicks. But on the industry side, that's a significantly different framework. So, you're going to see the implementation is going to be complex. But a number of advocates argue that that's a necessary baseline, especially in light of federal inaction. The last thing I'll say about the bill that we'll probably get into a little bit today is, obviously the concept of private right of action for consumers. And regardless of sort of business or consumer side's opinion of that is one of 2 things that has ensnared the conversation at the federal level for 3 years. So that's a difficult conversation. So in summation, there's a lot of debate on the best approach. It's definitely going to be an iterative conversation. And I would say, regardless of how you feel about the bill, you have to give some level of commendation to Senator Thomas and Assemblymember Rosenthal for addressing this complex issue, that Congress has yet to address in any substantive fashion. And I'll say, while it certainly scares the heck out of some businesses, it's an important policy conversation to be had. So, I want to thank City and State for hosting this event. To our panelists, Senator Thomas, Assemblymember Linda Rosenthal, Senator Diane Savino, Chair of the Senate Internet and Technology Committee, Myriah Jaworski, and Jack O'Donnell. And I would say, in closing for the opening remarks, I think we could take 3 hours and probably not touch every corner of data privacy. So if you have any questions or you want to reach out, please feel free. Our website is thedataprivacyalliance.org. So with that, I'll turn it over to Zach Williams.
Thanks so much, Jim, for setting the mood for our event today. And thank you for everyone for joining us. I'm Zach Williams, Senior State Politics Reporter at City and State. And we got a really great panel of people super involved in all the issues surrounding the New York Privacy Act. Let's see if my panel is joining me on video. Looks like, oh, we got one. Should have a couple popping in a second. So in the interest of time, well, before I introduce our panelists very briefly, I do want to just mention to the audience that we'd love to get you involved in the conversation. Just throw your questions right into that Q&A function that should be at the bottom of your screen, and I'll try to work them in as they come. Now, in the interest of time, I will not ask our panelists to introduce themselves. I'll just quickly say your name and your title, and please just wave to the audience so we know who we got here. The first person up is actually one of the sponsors of the New York Privacy Act, Assemblymember Linda Rosenthal of Manhattan. Her counterpart in the state Senate is Kevin Thomas from Long Island. And also super involved in all these issues is State Senator Diane Savino of Staten Island. And then it looks like we also have Myriah Jaworski, an attorney overseeing Beckage's privacy litigation practice group. And then batting cleanup for us right here is Jim Moore, Executive Director, of course, of the Data Privacy Alliance. So let's just jump right into it. So many acronyms in Albany, I gotta say, apologies. So I'm gonna throw this just straight to one of our bill sponsors, whoever wants to jump in first. You know, we got a little bit of an introduction to the New York Privacy Act a little bit ago, but maybe you could explain a little bit about the context that led you to help sponsor it, and then just where it is right now in the legislature.
All right, thank you, Zach. Thank you, City and State, for hosting. I'll take that question, and thank you to Jim Moore. He more or less summarized my bill, but let me talk a little about, you know, why I decided to do some research on this and start the framework back in 2019. When 2016's election happened, there was a lot of news stories and concerns about Facebook and Cambridge Analytica. Through the research, we also found that our data is more valuable than a barrel of oil. It's more valuable than gold. And we as consumers were giving up so much information about us for convenience. And that led me to the very first version of this in 2019. And the way I would summarize this bill would be, it gives more control to the consumer. It makes it more transparent, meaning the data that's being shared, where it's going to be shared to. And we've introduced a duty of loyalty and care. Because get this, me as an attorney, you've got financial professionals, you've got doctors. They have a higher level of a duty to their customers and their clients and their patients, and we need to do the same for those that collect our personal data and share it and sell it. So that's, you know, another summary of my bill. And right now, the status of it, it passed the Consumer Protection Committee. And we're looking forward to push on this when we restart session in January.
I'd also add some of the technical details on the bill, which it's a pleasure to work on with Senator Thomas, is some of the more controversial aspects, for example, the opt-in consent. And I know that that is one of the key points of disagreement, to put it kindly, among legislators and perhaps the industry. And that's where we're going to have you know, we'll see how this turns out. We also have a right to know how data is used, who it is shared with. The right to correct information provides consumers the right to request an investigation to correct any personal information. And anyone who's had their credit history wrongly recorded knows what a battle that is to fix. Right to deletion, regulate automated decision-making, duty of care and loyalty, registration of data brokers, and private right of action, which will also be a major point of contention. But this is something that the legislature is very, very interested in. In the Assembly, it's in the Consumer Affairs Committee, and we're working on it and hope to get it moving in January.
Oh my gosh, there's just like so many exciting things in there. Right to deletion, so many things. But that last one you mentioned sounds super interesting, and maybe this is where we bring Myriah in. Is private right of action. What are you talking about, and why is this so controversial?
That's right, Zach, thanks for that. Hi, everyone. Myriah Jaworski with Beckage Law Firm, a law firm focused exclusively on data privacy and cybersecurity law. A private right of action allows consumers to directly sue businesses. And the difference in the New York Privacy Act versus existing privacy acts, such as the California statute, is that New York has a much broader private right of action. So under the New York proposed legislation, consumers can presumably sue businesses for any violation of the act. So that's a violation in the wrongful collection, that's a violation in the wrongful storage and handling, and that's also a violation in a data breach. So what we saw in California is this fear amongst businesses that the CCPA's private right of action was going to lead to a tidal wave of lawsuits. Earlier in the presentation, Jim mentioned BIPA. BIPA is a biometric statute out of Illinois that has really hit SMEs and small businesses very hard. It was driven, as many of these acts are, by concerns over big technologies collection, but has really had an outsized impact on small and medium-sized enterprises. But we didn't see that tidal wave in California because there was a narrow private right of action. But there's certainly the concern among business stakeholders that this private right of action is just too broad, and that enforcement should really be limited to the New York State Attorney General or through the creation of a New York privacy agency, such as they've done in California.
Super interesting. Senator Savino, I imagine you talk to all sorts of people on about issues like this. What are you hearing? What really excites people about this bill and these issues, and what is making people a little bit worried?
Unmute myself. First of all, thank you. Thank you guys for hosting this really important panel. As you know, the Internet and Technology Committee was only created in New York State 3 years ago. And it's really, I think, a reflection of the fact that government is so far behind with tackling these new, very complicated, broad issues that affect all of us. Technology is ubiquitous in our lives. We can't even imagine a day where we don't have a smartphone, but it's really relatively recent in modern times. 20 years ago, none of us could have even contemplated such a thing as a smartphone, or even having a discussion about data privacy or data retrieval or how to collect it. And that's part of the problem. The vast majority of the general public doesn't realize what the risks are with respect to their data. They give it away every day, knowingly, unknowingly, willingly, and happily. I recently attended a conference of NCSL where the issue of data privacy and data protection was the subject of a 3-day conference. As I think Jim mentioned, there are 3 states that have comprehensive data privacy laws they've just adopted. The CCPA as well, has been well discussed. Virginia and Colorado have moved forward. The real problem, though, is we could be potentially at risk of having a 50-state solution, which would be a real challenge for businesses. And I don't think that's what we want. These are the kind of issues that really should be dealt with on the federal level. Unfortunately, the federal government can't seem to get out of its own way on anything. So I think it's important that if we are moving forward with a Privacy Act in New York State, that it be somewhat consistent with what's happening in other places, and it should make sense, right? One of the areas that I think that we have seen that none of the existing proposals has is some level of consumer education. If consumers are going to be protected, if they want to be able to utilize these laws, they have to understand what they mean. And I don't think most consumers really do have a sense of what the risks are to themselves. We've had, I heard Myriah talk about the issue of the private right of action. I'm somewhat conflicted on that. We're seeing in other areas of internet law where you have, I hate to use the term ambulance chasers, but for want of a better word, We're seeing there are cases being brought against small businesses who have websites by people claiming that they're violating the Americans with Disabilities Act. And what do I mean by that? Well, the grape growers of New York State were sued by someone because they claimed that they didn't adequately describe every grape that they grow so that a person who is visually impaired would understand that. Now that's silly, right? But you could potentially have things like that happening. So we have to be aware that if we're going to include a private right of action, that it be meaningful, that it doesn't lead to frivolous lawsuits. And then I think finally, I think we should work with other states to come up with a more comprehensive approach so that we don't have a 50-state solution. I mean, we could wind up at a place right now where a person would log on to a website that does business across the country. And you could have, if you're a California resident, click here. If you're a New York resident, click here. If you're an Illinois resident, click here. And that's silly. So we have to, I think, be more collaborative in our approach towards this. States are the incubator of ideas, and that's sometimes a good thing. In areas like this, it would be better if the feds led. I just don't see that happening. So I think we should be more willing to work across what's happening with our colleagues in other states who are leading on this issue.
That's super interesting and made my mind immediately jump to efforts to legalize recreational marijuana. There was a lot of talk, if you're going to do it in New York, you need to make sure Massachusetts, New Jersey, and not no race to the bottom, right?
It's a perfect example, Zach.
Well, it's like I do this for a living sometimes, but I'm thinking of Europe, and Europe had I forgot the exact acronym, but they institute some. I'm sorry.
The GDPR.
Yeah, thank you. And we've talked about California. So maybe who wants to jump in and talk a little bit about, maybe what other states are doing and how how New York is, what sort of conversation is even happening between, say, New York people, lawmakers in New York, Pennsylvania, Massachusetts, or wherever.
I just would want to make one point. The GDPR is not about privacy. It's about data protection, which is somewhat different. It's not exactly the same thing.
Thank you for clarifying that.
That's a great point, and I'll just add on to that. So we had the GDPR back in 2018, and many US-based businesses that collected information of European Union residents were required to comply with that framework, which is an opt-in framework. And so many of them dealt with compliance efforts under the GDPR framework. Now they're seeing the CCPA framework, same scenario. That's not an opt-in, as mentioned. That's a framework where businesses can continue to collect information from consumers, but they have to be transparent in their collection efforts, and they have to give consumers certain rights. And now we have the New York proposal, which, as mentioned, is an opt-in proposal. So there is it is a real risk. This inconsistency and this 50-state solution, as the senator said, is a real risk to businesses in the United States. We're going to see, and we have already seen, internet segmentation, offering segmentation. It is correct that as a California resident, you will see a different version of a privacy policy than residents in other states, and potentially will have different offerings available to you. And that's a really unworkable framework for many businesses.
Let me jump in a bit, Zach. Just want to touch upon what the ideal situation of the United States would be. That would be one federal law that just sets out all the rules for these internet companies to operate. But the reality that we live in, the federal government, both parties can't even agree on whether the sun will rise tomorrow. So states have to jump in and do what is best for their residents. So your question as to what's the difference here, right? So all the comprehensive state bills that we've looked at create a consumer rights model for privacy. In that way, the New York Privacy Act isn't different from California, Virginia, or Colorado, but there are subtle differences in the consumer rights model that the New York Privacy Act proposes. For example, the New York Privacy Act relies on that opt-in consent, which was talked about, and also contains a private right of action. I've heard concerns about it, but get this, it is being limited. All right, the A version of the bill that is going to be filed, it's going to be limited in there. My biggest concern as a civil rights attorney is the violation of civil rights. And those rights are ripe for violation when companies process data without oversight. We are narrowing the private right of action to apply only to those sections of the bill where we believe civil rights violations are more likely to occur. So opt-in, automated decision-making, and responding to requests. So I just wanted to make it clear on that front.
I also wanted to jump in about the failure of the federal government to address this. So we have no choice. As Diane said, we're behind, and government is usually behind technological and other advances in society, but we can't just sit on the sidelines. The other thing is, though, that when New York passes something, the nation watches and often tries to duplicate. So we're not the first here, but I do think it's important that New York try to lead in this area. And so that's why discussions like this are important. But really, I think we have our finger on the pulse of our constituents who, you know, whether it's like, oh, I Googled something and now an ad about that product is trailing me everywhere I go. People feel that and they know that, but they're not sure how to address it. And that's why I think opting in and education is all very important.
That's
I want to follow up on that though, Linda, because I think that's a large part of the problem. Most people don't really understand that this is an issue at all. The reason why those ads are following them is because they've opted into something because they think they're getting something of value. So whether it's the rewards programs that you sign up for, or the membership cards, or you just want to get to whatever the website is because you purchased something and you've signed up for something. And that's how we're giving away our data. So part of whatever we do has got to include consumer education, so they don't put themselves in a position where eventually, as Senator Thomas said, there could be a civil rights violation of the misuse of their data. So
well, I agree with you.
Right.
I said that.
Right.
Yes.
It has to be part of the problem. And I will tell you, I'm as guilty as anyone else. Sometimes I just want to get to whatever it is I'm looking for on the internet, and I'm giving away my data freely. And do I have the time to go back and retrieve it? That's another problem. One of the reasons why this is so complicated is the end user agreements are so long, no one reads them. They just click all the way down and accept. And so if we don't address that and make it simpler for consumers to understand, we could wind up with a complicated statute that businesses have a hard time complying with and really doesn't produce any protection for consumers.
But I think the basic tenet is that our data belongs to us, and we have to view it from that lens. It's not the company's right to profit and disseminate our data. It's our personal private data that we have been giving away, but we have to change that model.
And I think that a lot of the conversation today is really around internet tracking and cookie tracking. But the reality is the threshold of the New York Privacy Act, just as with the CCPA, impacts businesses that aren't engaging in these activities. It impacts businesses that are collecting personal information in other contexts where the consumer understanding and expectation is very much consistent with the business practice. So I do wonder if there's opportunities to refine or focus more towards internet tracking, cookie tracking, data brokers, which I believe even across business, there's understanding that those are areas that need regulation, and to really carve out or have a threshold that doesn't apply to, you know, many of the SMEs that can be potentially impacted.
On that point, the thresholds are very high. My staff has asked every association to tell me their smallest company wrapped in and what that threshold is. So, you know, we are doing everything that we can to carve out those that this should not really apply to. In terms of the cookies, you know, it's not an opt-in here. They fail to opt out. Like the consumer has failed to opt out. That's why those cookies are following you and giving you all those ads. There was not a conscious decision to allow companies to collect. You know, the companies also aren't giving a real choice to avoid collection. So, you know, I just wanted to make that point there.
Yeah. Zach, one thing I want to mention on that point, you know, as far as, you know, we've mentioned federal inaction a few times, right? And I think, you know, what does that look like when there is federal inaction or federal action? You know, and on financial markets regulation, you know, you have the SEC, but you also have DFS. So I do, you know, I think from my perspective that, you know, the state will still have a role in this, you know, even when there is an overarching federal standard. You know, and you look at some of the complexities of the data you're sharing, you know, I think the landscape's going to go from, you know, you take a zettabyte, that's a trillion gigabytes, you know, by 2025, we're going to have almost 100 times, you know, 100 times the amount of zettabytes out there that we have now through the Internet of Things and in various areas that, you know, so it's going to be a very complex, you know, framework. So I do think, you know, there is going to be a federal role and a state role to play going forward, even when the, you know, when it is all ironed out at the federal level.
So time flies while we're having fun. There was one feature of the bill I really wanted to zero in on to better understand the consumer side of this, the right to deletion. I could imagine that this might be somebody maybe was convicted of a crime a long time ago or accused of one, or something false was put online and they want it gone. But you tell me, what is this? How does it work? And, you know, how accessible is this for an ordinary New Yorker who, you know, doesn't have an attorney, doesn't know privacy law, but just wants something deleted for ostensibly a legitimate reason?
So I'll jump in on that. All right. So in a time, I mean, this has like a bunch of different intentions here, right? So one of the intentions is in a time where we are being hit with a lot of cybersecurity threats, to have so much information about us just sitting there is just calling for hackers to basically jump in and say, oh, this is great. This company has so much information. They're not deleting things. That's great. Another point that comes into mind is when we are requesting information from these companies to see what they know about us, and if there's something not true, we can put in a request to delete that you know, that information that does not connect us to reality. So those are like the two intentions there behind that right to deletion in this bill.
I would add that from the business perspective, having worked with many businesses to implement a right to deletion under the CCPA, this is not something that's scary. This is something that I think many businesses welcome, because there is a reality that they are hanging on to data for too long. They haven't gone through data mapping exercises. They are not necessarily very aware of where information is stored on their systems, how it is secured, and how long it is retained for. And the default assumption in some networks is to retain information indefinitely. And that is not a good cybersecurity practice, as Senator Thomas mentioned. So the right to deletion, I think, is really an opportunity to look at your network, look at the information you're collecting, and to innovate. And so businesses there, I think, are in agreement that there's a good business purpose behind this as well. There are going to be exceptions to the right to delete, right? If I'm engaged in a transaction with you, I can't delete your information. I need to complete the transaction. If I have a federal requirement to retain your data under a federal or other state law, I'm going to retain your data. But in general, I don't think the right to deletion is a very scary right on the business stakeholder side.
Yeah,
one of our audience just asked, how's the, I'm sorry, Jim, go ahead.
Yeah, no, I was just going to say, I agree with that as far as, you know, the direction a lot of business stakeholders are going. I think you see, especially in fintech, you know, data minimization is becoming kind of in vogue, and streamlining your processes internally, you know, to make sure you aren't having sloppy and extemporaneous data, you know, sitting around on your servers. And I think, you know, deletion and policies like that push companies in the, you know, kind of in the right direction as far as data minimization. So I think, like Myriah said, that's one of the least scary parts of the bill. And I think, you know, many businesses sort of are already kind of heading in that direction.
It's like you read my mind. You set up my next question perfectly, Jim. Well, one of the audience members asked, you know, how is the financial services industry affected by this? You know, big part of the economy, very, very unique to New York. You kind of alluded that the industry seems to already be going in this direction to some degree, but What are you hearing? What sort of concerns? For whoever wants to pick up this one, including the bill sponsors, maybe.
Yeah, so I think I'll touch on that quickly and then kick it. I mean, when I talked about sort of the complex mess of federal laws that are out there, I mean, one of those is Graham-Leach-Bliley, and the FTC Act. So to a certain extent, and also you look at some of the things FINRA and SEC are doing. There is sort of a swath of laws around financial data already, and this bill does contemplate all of that. So I think, interested to hear in more technical detail, what Senator Thomas and Senator Rosenthal think. But right now, as far as financial data, financial data is already regulated in the federal space. So there is, this bill will sort of build off of that, that baseline.
That's right. I mean, as Jim mentioned, we see PFI regulation going back a few decades now. So the financial organizations and entities that we represent are very much aware of their obligations. I think this might uniquely impact fintech, some of those financial startups and apps, which is interesting. And I think that regulation would be valid and understood. But this is an industry that is used to regulation. And to Senator Thomas's earlier point about the cybersecurity and data breach risks, if your PFI is impacted in a data breach, there are real risks associated with that. And as an organization, you may be facing a data breach class action. So protecting that, securing it, making it available in certain narrow contexts is something that I think is in the business's best interest.
So the GLBA sets a baseline and allows states to have stricter requirements. We've just opted in to exercise that right. But like I said in the very beginning, financial companies already have a sort of duty of loyalty and care. And we need to exercise that for data.
Duty of care? What is that?
So it's a duty of care and loyalty, right? For example, like I explained in my example about lawyers and clients or doctors and patients, the personal information that they give out, that they know about you, they have it secured somewhere. Like they're not allowed to give out that information without your consent. That's basically the intention behind what my privacy bill does. Its care is data security largely, and just data minimization.
And data brokers, who are these people? And why should they be registered like other professions, I assume?
Well, because they are unregulated right now, and they can, buy and sell your data to whoever they want to.
But I mean, who are these? Are these people that work for big, Google, or are they people that work for mysterious firms we've never heard of? That then, who exactly are these businesses?
All of the above.
I think the data broker concept, it really starts at the big tech, right? It is the organizations and entities that support the Facebooks and Googles of the world, but they're also providing B2B and B2C services to other organizations and other industries. But certainly data brokers, more than any other company or any other industry, is collecting personal information and profiting off of the collection and sale of it. So this is really a narrow subset of all the entities that could potentially come within the regulation of the Privacy Right Act.
Now, let's say some company, you pass the bill, it becomes law, and people don't obey it. I'm sure they would. They would have. People always follow the law, but let's say they don't. Is the private right of action the sole enforcement mechanism here, or are there other ways to kind of to enforce these various provisions?
No, private right of action is not the sole mechanism here. We also have the Office of Attorney General. But again, the private right of action is limited in scope, and you'll see that in the A version of the bill that'll be filed soon.
In addition, the Attorney General is limited in terms of staff allocation. And I think having the private right of action in this however more limited than the original version, also puts a little fear in the hearts of companies that think regulators are too busy to follow their particular data collection practices.
I think that I'm happy to hear that the private right of action has been limited, and I look forward to sort of reviewing the refined scope. I think that there is a real risk, as Senator Savino mentioned earlier, with the ADA website accessibility lawsuits that are brought. Those lawsuits are filed, I mean, thousands are filed a year, and they are filed primarily at this point against small and medium-sized businesses. And then in BIPA, we saw the same thing in Illinois. You know, motivation by big tech, motivation to kind of go after the Facebooks and TikToks of the world, but the real, disproportionate impact to small and medium-sized businesses. So plaintiffs' attorneys who see an attorney's fee provision, they're not going to look at whether a business necessarily has the wherewithal to sustain a lawsuit. And what a lawsuit would do to the business's operations, and they're just going to commence an action. So there is a real risk that a private right of action could be used to just target businesses frivolously.
Mm-hmm.
Would you be able to provide a few more specifics, Senator Thomas, on how the bill will change when it comes to the private right of action?
I don't want to give out too much. It's still a work in progress. It's not finalized. There's still, associations and members that are still commenting. So I can just tell you the private right of action is limited because it was one of the biggest concerns that a lot of associations had.
And what's kind of the end game here? We were talking earlier about, these enormous privacy policies that Senator Savino is hardly the only person that just clicks through them because you want to get to where you're going on the internet, and it's impossible to do things without it. What would a future consumer see? Would they see like a very bolded list that very plainly says it? Would it be some other experience, or is the intent that they don't even need like such a privacy notice at all?
It could be, I mean, look, I described earlier somewhat flippantly that you could have 50 different click-offs. That the likelihood is that wouldn't happen. You could get one standard one. You could get most commonly used one. As I said, I spent a few days at NCSL, and one of the presenters there was a presenter from the Uniform Law Commission. Every state has people, every state belongs to the Uniform Law Commission. We send people there. In fact, we have representatives who participate in drafting sample legislation around these complicated issues, and they've come up with some recommendations for states to adopt. I'm going to share it with Senator Thomas and Assemblymember Rosenthal. Some of the very recommendations in their proposal on a Uniform Personal Data Protection Act is incorporated in the New York Privacy Act. So I think there's a lot in commonality that we could work on, and I think what's going to continue to complicate this area is that most of the bills that have been introduced and are either passed in California, Virginia, Colorado, and that are being contemplated, including here in New York, address devices that have keyboards, whether they be virtual keyboards or laptops. We are rapidly moving beyond that. Data is collected every day on things like your Fitbit, your smartwatches. Mark Zuckerberg is, advancing forward into what we call the metaverse. None of these data privacy laws will affect what's called the metaverse, which is artificial intelligence, the glasses, all of those things. So this is going to be an ever-changing, ever-evolving area. How do we protect people and protect their data and make sure they understand what that means, what they're giving away, what the value of it is? I couldn't tell you. I spent a lot of time, in Senator Thomas, he and I have discussed this ad nauseum. I couldn't tell you what the value of data is. Like, how do you put a dollar amount on it? I really don't understand it. And if I can't understand it, I'm not sure how we can explain it to people. But there is a real danger inherent to it. And I think, and I'll end on this because you guys are way smarter than me on this, and the sponsors really want to talk about it. One of the other challenges we have is how do we then prevent local governments, because everybody wants to get in on this, from passing a whole myriad of laws to try and address this on their own, which will only complicate it even further for businesses. So as I said, it's an exciting time to be a legislator on issues like this, but it's also an incredibly complicated one. And I'm just happy to be surrounded by smart people. Certainly smarter than me.
I just want to jump on what my good friend Sandra Savino said here. Listen, the ever-changing privacy landscape that she just described is exactly why we need states to legislate. And the last time the federal government got involved with internet privacy was the 80s, before the internet was even created. And that's like the Electronic Communication Privacy Act, and that just prevented the government from not snooping on your phone calls without a warrant. So and the laws haven't been updated since. So that's why we need the states to jump in. But from what I've been seeing, even when California and Colorado and Virginia and all those other states passed their data privacy laws, the companies like Microsoft and Google, they go with the strictest version for the entire US. So it's not that if you go to California, Microsoft is operating in one way, but they do it throughout the US.
And I think those are the types of decisions that national and global businesses can make, but businesses that are more regional, and certainly businesses that operate only within the state, they don't really have the luxury of deciding to use the California standard, the GDPR standard, and roll that out across operations.
I forgot to kind of ask, does this bill have any bearing on how government holds, uses information, or the privacy safeguards of that, or is this purely private sector? Uh-oh.
It applies to government for, if there's a sale of information.
I'm sorry, say again?
It applies to government for, like, if there's a sale of information. We exempted government otherwise because the government needs to be able to share information between agencies to fulfill their statutory obligations.
Police departments to Department of Health or whatever it is.
Yeah, something along those lines, yeah.
So one audience member just asked for clarification. I think we've gone over this a little bit, but they just want to know, for the sponsors, do the New York State legislators proposing this bill support the idea of federal preemption of New York's law in the event Congress subsequently implements a federal privacy law?
Nope,
Well,
no way.
No one ever supports preemption.
yeah, we don't like preemption, but
Except when we're preempted.
We're preempted.
Right, we only support it when we're the preempting body.
Exactly.
Well, how would that work? They're the federal government, so can't they pass a law that would supersede a state law, or is it not?
They could,
can.
absolutely,
They can.
but we would object, and they might win. But again, no legislative body wants to be preempted by someone else. New York City hates when we preempt them, and we remind them all the time that they are a creature of the legislature. They hate that, but they are indeed a creature of the legislature.
Well, you were meant, so then I would assume that the intent then is to create a model that here in New York that Congress would then adopt, thank Assemblymember Rosenthal, State Senator Thomas, and put it across the whole land, right? That would be the ideal situation.
That would be the ideal situation.
Ideal.
I would love to see that.
And I'm sure right after they get done, delivering on
Yes.
the package that they can't agree on, they'll get right to work on data privacy and cybersecurity and
Yeah,
the other
absolutely.
challenges.
I mean, we could have some climate change legislation.
Oh,
go
yes.
next, who knows?
But in
By
fact,
lunchtime.
the states are leading in various areas because of the paralysis in Washington. And we have to continue to do that in the area of climate, in this area, and many other areas where they're so polarized, they can't even agree on like what time it is.
Mhm.
And it just leads to a really unfortunate regulatory and litigation climate, because even though, of course, the state doesn't want to be preempted by the federal government, when and if we get that federal law, the first thing the business sector is going to argue is that the federal law preempts the state law. And we're going to see 5 to 10 years of litigation over what type of preemption is at play. And it just leads to uncertainty. And and that is, I think, what really we should try to be avoiding. We need clarity, we need certainty, and we don't need that 50-state solution if possible.
But
Yeah,
in the absence of action on the federal level, we have to proceed. But I think we all take into account that the gravity of the potential of this bill. So we're not doing it in a vacuum, as Senator Thomas said earlier.
We're almost out of time, but I'm sorry, Jim. Just want to get in one quick question. In case you haven't heard, we have a new governor. Have there been any feelers from the administration, any signs that, of how they might approach this issue differently than her predecessor?
So her predecessor actually had a version of data privacy in the budget. Last year, we rejected it because it was too watered down. We're in talks with the governor's office again, and let's see where it goes.
All right, just a few minutes left. Was hoping that each of you could just offer maybe a 30-second takeaway, something that people in our audience can tell to other people after the event. We'll start with you, Senator Savino.
I just want to thank you all for hosting this. And the only thing I will say, I've said enough, but I will end with this. I'm hoping that as these conversations continue, that more and more people become aware of the potential risk of misuse of their data, and they become engaged. I will tell you, I get stopped by constituents all the time on a whole host of issues. No one ever asks me about this, but people really need to understand what is at stake, what the value of their data is, and why it needs to be protected. And to the extent that constituents become engaged, we'll wind up with the best policy that will be the leader that Assemblywoman Rosenthal and Senator Thomas want it to be. And then it'll be a policy that businesses can get behind. And I would hope that we'll be that leading state.
Thank you, Senator. Myriah, one takeaway?
I would just piggyback off of that and say engagement with the business community is absolutely an important step as this legislation proceeds. And to go back to an earlier point, not every business is profiting off of the collection of personal information. Many businesses collect this for relevant and important business practices. And we need to work with those businesses because they view parts of this law as opportunities to innovate, parts of this law as opportunities to understand their network. And then we need to just ensure that those concerns regarding the private right of action and regarding some of the regulatory risks of the legislation are understood and heeded.
Jim?
Yeah, I would piggyback off what Myriah said to continue the trend of piggybacking. I think there's an important conversation to be had between industry and government regulators, and I think regardless of federal inaction, that at a certain point there will be a state role and a federal role in this policy area. And I commend Senator Thomas and Senator Rosenthal and additionally Senator Savino for considering these issues on her committee. For tackling these complex issues. You've seen the paralysis in DC, around really 2 issues within it, and that underscores how complex it is.
Thank you. And Senator Thomas?
So I'll just put it this way. If you aren't paying for a product online, you are the product. New York residents need protections. The provisions of this bill will be complex to comply with because they require companies to take a real look at the data they have, why they have it, and what they want to use it for. Get consent for the uses and to delete data they don't need. But good data practices pay off because consumers feel their rights are being protected.
Thank you. And Assemblymember Rosenthal with the last word.
Thank you. Thanks for holding this. Very informative. I hope for the people who are watching. I had a case in my district where a landlord was requiring a lot of data about who goes in and out of the building, and then they were using that data to try to evict tenants who they thought were misusing their rental. People understand that. Whether people understand the entire scope of what can be mined and used of their private data is something that we need to do education on. We need to bring the consumer better into these discussions, because I think small business and larger businesses are well represented, and we are engaging with them. But I also think the consumer needs to tell us, what is it that you're most worried about, and how can we help you navigate these thorny issues? So I look forward to doing that.
Thanks so much. And thank you all for joining us on the panel. This is such an important issue, but it can get very complicated. Thank goodness we got people that are well read on these things, because I know I learned a lot on this panel, and I'm sure many members of our audience did as well. So thank you again for imparting us with some important details on this super interesting bill. And thank you everyone to our audience for for hearing the discussion.
Thank you.
Thank
Right.
you.
Thanks.
See you all.
Yeah, and in closing, you know, just want to thank the sponsors and Senator Savino for taking the time. You know, like I said, this is an extremely complex issue. It's been an iterative process with a lot of feedback from industry. So, you know, thanks to everyone for taking the time, for tuning in, and you know, if you have any questions going forward, please, you know, reach us at thedataprivacyalliance.org. Thanks a lot.